Statement on the Sentencing Reform Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament's website.
I move that the Sentencing Reform Amendment Bill be now read a third time. This bill is a significant piece of legislation that delivers on the coalition government's manifesto commitment to restore law and order and to ensure that there are real consequences for crime. It also delivers on a specific promise in the government's third quarter action plan to introduce legislation that ensures real consequences for criminals. Madam Speaker, under the previous administration's misguided approach to crime, which focused on reducing the prison population by 30%, regardless of what was going on in our communities, we saw an alarming increase in violent crime, ram raids and aggravated robberies. Why? Well, in part, this was because criminals knew that they would get away with a slap on the wrist and light sentences. We know that the undue leniency has resulted in a loss of public confidence in elements of sentencing and in our justice system as a whole. And we've developed, sadly, in this country, a culture of excuses for crime. That ends this week, Madam Speaker. The reforms have three key objectives: making sure that punishment fits the crime, restoring the principle of personal responsibility, and better recognising the victims of crime. First and foremost, our reforms today, which will pass, will limit sentence discounts that judges can apply to 40%. Kiwis are sick and tired of seeing brazen criminals who have been convicted of serious offences sometimes resulting in the death of fellow New Zealanders, people who are sons, daughters, loved ones of New Zealanders, or injuries that blight their lives forever. People who have been convicted of these crimes receiving massively discounted sentences for a whole variety of reasons, sometimes to the extent of not actually being imprisoned. In recent years, we've seen serious crime increasingly coming before the courts, but the response has been counterintuitive: a reduction in the use of imprisonment and shorter prison sentences overall, much to the dismay of victims. Parliament, through this bill, is sending a different message. And we're putting a limit on the overall discounts. And there's been a lot of debate around this, or is this somehow unconstitutional or unfairly or inappropriately limiting judicial discretion. Of course, Parliament sets the sentencing framework, and the framework in New Zealand currently is a maximum sentence is put down in legislation, and there is judicial discretion under that. It is quite. We could do things in a different way. We could have minimum sentences. We could have mandatory sentences. We haven't moved to either of those things in this relation to this, but we have, through Parliament, sent a clear message that we're not content with very substantial discounts for a host of reasons, and we want to put a limit on it. And it is disappointing that the Labour Party is opposing this. We heard on a number of occasions after the election there was reflection. I remember from the leader of the opposition, Mr Hipkins, saying that perhaps they had been too slow to respond to retail crime and community concerns about these issues. Perhaps they had. They reflected upon that, but they seem to have forgotten that message. They seem to have forgotten, and they've gone back to their old ways, which is to never support changes that will actually bring real consequences for crime. Of course, I'm not surprised that the Greens don't support this, and they refer to this as fear-mongering. I don't think if you talk to the victims of crime in our community, you go down to a main street of Papatoetoe and talk to the retailers who are suffering and living in fear and surrounded by cages in their stores because of the extent of violent crime, you say that they're fear-mongering, I think you will find you get a very hostile response. So what we're focused on is making some real progress. Secondly, we're putting an end to the repeated discounts for youth and remorse. We believe sentences should primarily respond to a person's decision to commit a crime, not solely focus on their circumstances and background. It's particularly frustrating for victims when offenders receive a sentence discount for expressing remorse, not once, but in every subsequent instance of reoffending. And so we absolutely want to make some allowance when a young person, and when we're talking about a young person, we're talking about people typically between the age of 18 and 25. We're not talking about 12-year-olds, that's dealt with separately. Yes, you can get a discount for being young and remorseful, but not on multiple occasions. That makes a mockery of the justice system. These reforms will restore the principle of personal responsibility. We particularly want to condemn certain types of offending, such as where the offender live streams or posts their actions online, or where an adult offender commits or was party to an offence committed by a child or a young person. And on those occasions, we're thinking of the fact when you have an adult driving a car with a bunch of teenagers doing a ram raiding, well, that adult needs to take greater responsibility because they have led younger people into a crime. Importantly, this bill will recognise the needs of victims, particularly those who have suffered from years of increased retail crime, encouraging the use of cumulative sentencing for offences committed while on bail, in custody or on parole, amending the principles of the Sentencing Act to have a stronger focus on the victim's needs and interests, and introducing a suite of new aggravating factors for offenders who are targeting victims working alone, those whose homes or businesses are interconnected, and public transport workers as well. But I think of particularly people working in dairies, for example, where they're living upstairs and they've been subjected to ram raids or violent offending downstairs. That has a horrendous impact on the family and the fear that is associated with it. And I'm frankly amazed and shocked that we're not getting support across the House for this legislation. Retail crime increased by 85% between 2019 and 2023, including a 91% increase in victimisations relating to theft. Small business owners have been left feeling powerless and at the mercy of those who rob their livelihoods. It's only right that offending against people who live in fear of theft and assault, often with their families nearby, upstairs, result in a tougher sentence. The sliding scale for guilty pleas will be implemented with a maximum sentence discount of 25% if guilty plea is made at the earliest opportunity. But we're not going to give 25% if it's on the morning of the trial. Only 5% is available at the last minute. Earlier guilty pleas will spare more victims from having to prepare for and give evidence at trial and help improve timeliness. And so we're determined to do that. So we've also received the opportunity to progress a couple of recommendations from the Royal Commission of Inquiry into Abuse and Care, and specifically amending the existing aggravating factor that requires the court to consider the particular vulnerability of a victim by adding in state or faith-based care as an example of vulnerability and may be known to an offender when the offence was committed. And secondly, the requirement for the court to consider additional aggravating factors in cases involving violence against or neglect of a child under the age of 14, so that they can also apply to cases involving a young person who is under the age of 18. They were recommendations of the Royal Commission and we're happy to progress them in this legislation. I extend my thanks to the Justice Committee, the Sentencing and Rehabilitation Team at Justice, the Parliamentary Council Office for their work to help this passage of the bill through the House. Madam Speaker, in conclusion, we've set two clear targets: ensuring that there are 20,000 fewer victims of violent crime by 2029 and also reducing serious repeat youth offenders by 15%. This is a significant milestone in this government's mission to restore law and order. It signals to victims of crime that they deserve justice, and to the wider public that the government is committed to ensuring that they feel safe in their homes and in their places of work, and I commend this bill to the House.
The question is that the motion be agreed to.
Madam Speaker?
I call the Honourable Dr Duncan Webb.
Thank you, Madam Speaker. I mean, criminal justice isn't simple, and it's not simplistic, and that's what this bill is. And I found it a little hard to listen to the Minister talking about how his government is allegedly making progress on a target to reduce victims of serious crime, of violent crime, by 20,000, when in fact they've gone up by 6,000, and the best he can do is find a tweet with some misleading figures to trumpet his government's success. This bill is a knee-jerk reaction. And look, in other areas we are supporting the government's work, particularly around the experience of victims in court, and we agree that there's work to be done and we need to do better in looking after victims. But sentencing in particular